first of all, a couple of housekeeping items. I would like to thank Kevin Fort for adding a couple of things to my talk, which he mentioned that I was going to talk about that I wasn't. So, okay, I better talk about that. The other thing also is because I am a lawyer, I've been asked by the firm to just make it clear that the content of my presentation and the paper that I put into the materials is for your information only, and it does not constitute legal advice specifically to you or your organizations. Okay, so I am going to talk about the Migratory Birds Convention Act in terms of the law and the law of due diligence. If I find the clicker here. Some of the slides I have are repetitive of what Kevin had. I will probably go through those fairly quickly. I tend to get stuck on slide 3 and never get through the rest of the talk, so I'm going to try not to do that. But the key prohibitions in the Migratory Birds Convention Act, as you've heard, are harm to birds, depositing of harmful substances into areas that are frequented by migratory birds, and harms to nests and eggs. There are others which don't usually affect most of the people in this room that do. There are a lot of specific prohibitions related to shipping. And I don't think most of you are in the shipping business, so. The key terms to understand, and you guys, I'm going to go through this very quickly because I know you understand, is the difference between direct harm and incidental harm, or what's known often as incidental take. So these are the provisions that Kevin put up before. You can't hunt a migratory bird, and the definition of hunt is there. Kevin had it on his slides. Now, Kevin mentioned that there is some ambiguity here in this provision. This relates to, this is the prohibition against harm against birds themselves. And it is broad in the sense that lots of different activities fall into the rubric of what you, of hunt. Hunt is not just getting out your gun and killing it. Hunting can be harassing it, capturing it, injuring it. All those fall into the definition of hunt. However, as Kevin pointed out, there is this terminate, the word attempt in there. And the word attempt has been interpreted. First of all, we've never had a legal interpretation that I'm aware of this provision in Canada in terms of a challenge to whether or not that includes incidental harm. The general opinion amongst the colleagues that I work with is that it does not. And that is because the word attempt and the whole way the way the section is worded seems to imply that there is an intention that your activity is directed to the bird. So it's not going and cutting down a tree and there's a bird up in the tree, unless you say, we gotta get that bird out of the tree, let's cut down the tree. That would definitely fall into it. But it is a subtle difference, but it's an interesting one that has not actually been tested by the courts in Canada. It has been tested by the courts in the United States. And there is a decision from the US court in which it actually said, and their provision in the United States is not exactly the same as this, but it has some similar wording, and the court actually said it doesn't include incidental take because it is directed at the bird. So it's, again, the jury's still out on that one, but our view at the moment is that birds themselves are not entirely protected from incidental take. And when you think about the number of people who, hit a bird with their car or whatever, if birds were protected from incidental take, every time you hit a bird with your car, you'd be breaking the law. There are, as Kevin pointed out, a number of different permits you can get under this, and they relate to specific activities. Then there's the prohibition on deposit of substances. I'm not going to spend a lot of time with this. I think for most of you, the nesting provisions are the things that you're concerned with. But these provisions are fairly extensive. I'm going to nip through them and just talk about some cases. There have actually been a number of enforcement of these provisions. Going back to Neptune Bulk Terminals, which was a number of years ago, I came to work one morning and looked out my office window at Burrard Inlet, and it had a nice little sheen on it. What happened is Neptune Bulk Terminals, they ship bulk overseas. In this particular case, it was canola oil, and they had a hose that they were loading a ship, and a hose broke. The hose was under a dock, and it wasn't spotted for quite some time. and there was a nice sheen of canola oil all over Burrard Inlet, and some birds got harmed. Some Canada geese got harmed. So they were one of the first that I'm aware of prosecutions under these provisions of large substances. There have been a number of others. I won't go through all of them. Some of them have been a little strange. The McCain one is a little strange. The McCain one actually involves some seagulls that went into a dumpster where some maintenance workers had left some open paint cans, and the seagulls ate the paint cans and died. And they pled guilty to depositing a harmful substance in an area frequented by a migratory bird, which of course dumpsters and seagulls. So yeah, you can get some unusual things. The big profile one was the Syncrude case from a number of years ago, where so many 1,600 birds died when they landed on the pond and on their settling ponds in the early spring. The deterrent, they have deterrents for that, primarily cannons. They were not functioning yet. It was early in the spring, and the birds decided it was a great place to land. So, and the most recent one is the Canaport case out of New Brunswick. This was a really terrible situation where what happened was it was a fog event. The Canaport LNG facility is right on the coast, and they had some flaring, and I gather, and for those of you who are bird experts probably know this better than I do, there's something happens when there's fog and flaring together that disorients the birds, and they came in one morning essentially to find 7,500 dead birds in their facility, including 4 endangered species. So they eventually pled guilty, paid a $650,000 fine. I think it was, have I got 750 up there? I can't read it from here. Yeah, there's a breakdown here, but 125 of it or 150 of it is actually under Species at Risk Act, and then the rest was under the Migratory Birds Act. And a significant portion of that was not cash. It was donations or not donations, sorry. There was payments into specific programs for research and things like that. None of that's a donation. Okay, so this is the provision that you're all here for, and Kevin went through it. This is a prohibition on incidental harm to nests, and I'm not going to go through that because Kevin already did that. So historically, there was very limited enforcement of this, and Kevin mentioned that the complaint to the Commission on Environmental Cooperation. I want to talk about that just for a moment. In 2002, there was a complaint filed by a number of NGOs with the Commission on Environmental Cooperation. For those of you who don't know what that is, NAFTA has a side agreement on environmental cooperation between the 3 countries that are parties to the act, or excuse me, to the convention, and it, among other things, sets up a commission whose job it is to investigate complaints against any of the member countries that they are not enforcing environmental laws, and they are actually based in Montreal. And if you can go on their website, you'll see what the current complaints are. So NGOs, individuals, and other governments can bring complaints to them, and they will investigate them. They don't have any enforcement power, but what they can do, of course, is embarrass a government. They'll ask for submissions from the government, and ultimately they'll issue a report saying whether or not they're enforcing. This particular complaint was related to the nesting provisions of the MBCA and in relation to Ontario logging. And ultimately, the CEC concluded that, in fact, it wasn't being enforced. That actually led to some changes on the enforcement side, but also on the regulatory changes to the Act itself. And I'm going to get to those in just a moment. Oh, it's actually right here. I'm sorry. On this slide, you'll see at the bottom, there's an amendment on the MBCA, which was put in I'm sorry, I think it was 2000. I don't have the date in front of me. It's mid-2000s. They added this H.1, and what it does, it allows essentially the government to create regulations for conditions under which incidental take would be legal. So a permitting system, a regulatory system, whatever. And that is what led to what Kevin was talking about, these several years of attempts to find a way to do that. And given the complexity of it, given the ubiquitousness of birds, and it eventually, because of resources and because of a number of other reasons and because resistance from different groups and a lot of differing opinions, it kind of fell by the wayside. And they took a different approach. That led to another complaint, which I don't have a slide on, but that led to a complaint from EcoJustice, who filed a petition with the Auditor General of Canada respecting the abandonment of the Migratory Bird Nest Permitting Regulatory Initiative and the ongoing failure to comply with the North American Agreement on Environmental Cooperation, which is that NAFTA side agreement. The petition asked for an explanation of when Environment Canada would begin to enforce Section 1, essentially the nesting provisions of the regulation with respect to logging and other industrial activities, and to articulate timelines and explain the abandonment of the proposed regulatory framework. I'm going to read you the answer they got from Canada. Again, this is the Auditor General doesn't have any enforcement activity, but he gets to ask a question of Environment Canada. They have to answer it, and it becomes a matter of public record. So what Environment Canada's answer was this. Environment Canada is effectively enforcing the Migratory Birds Convention Act and subsection 6A of the Migratory Birds Regulations, undertaking a series of important actions that support this enforcement. These activities include training and designating enforcement officers, inspections and investigations, which have resulted in fines in a number of cases, and compliance promotion. Environment Canada works with stakeholders to support and promote the development of sectoral beneficial management practices to help implement the Migratory Birds Convention Act 1994 and further enhance compliance. This approach allows the department to address the highest threats to the conservation of migratory birds and remain focused on compliance and enforcement of the prohibitions of the Migratory Birds Regulations. So it's a fairly typical government answer. I mean, they have to couch their answers, but essentially what they're saying is we are increasing enforcement and we are working with industry on best management practices. But as Kevin correctly pointed out, what they can't do is say, if you follow these best management practices, you won't be breaking the law, because in fact, that's not the case, and that would be officially induced error. So they can't do that. So here's some examples of cases. I'm going to get up here for this, because I can't see these slides very well. Okay, so I'm just going to talk about a couple of specific cases. This first one here was a land developer in Langley. And he had all his municipal permits, he had some fisheries permits, he had all this stuff, and it was basically clearing off a lot that had been used years before and then had sort of grown up with brush type small trees, etc. He was clearing it for commercial development, and it caused a disturbance to nests. The evidence was that there was one robin's nest, and this is, Kevin alluded to something here about the problem with enforcement. In terms of enforcement, when you are actually an enforcement officer or a Department of Justice prosecutor, you actually have to prove that this happened. And so having what Kevin called a smoking gun, I would call evidence, is very helpful. It's very helpful. And in this case, they had evidence. They had a robin's nest on the ground with broken eggs in it. And in that case, the company actually paid a small fine. What actually occurred in the case is that the wildlife officer came by and said, you have to stop because you're actually harming, there's active nests in these trees. The company was surprised. They did have an environmental consultant. They called their consultant came by. They started flagging all the trees that they could find nests in, and they left them flagged and very slowly cleared the lot over a period of several months. It was a warehousing complex, and warehousing complexes for retailing need to be up and running by mid-summer in order to meet the Christmas rush, and they missed it. So they essentially lost a year of business. But the $10,000 fine was not the real impact on this company. It was much higher than that. J.D. Irving, this was a harvesting contractor, drove a feller buncher right through a heron rookery in New Brunswick. This one, the company ultimately pled guilty and paid a fine, but before they did that, they actually brought a constitutional challenge. They actually challenged this nesting provision under the Charter, the Canadian Charter of Rights and Freedoms, under the premise that it's too vague. They lost. And after they lost the constitutional challenge, then they went ahead and pled guilty and paid the fine. So that was interesting because there have been, the only other constitutional challenges to MVCA that had occurred go way back in history. There were a number of constitutional challenges as to whether or not the federal government had the authority, whether it was provincial or federal. That was actually settled a very long time ago by the courts, who said, yeah, they do. And I could explain why if anybody's interested, but it's, you know, it's one of those boring constitutional law things. But either way, this was the only constitutional challenge that's happened recently, and it was unsuccessful. It didn't go any higher than the provincial court in New Brunswick. They decided not to appeal it, which is a little unusual with constitutional cases. They usually go higher than just provincial court level. So, but anyway, so that was unsuccessful. So if anybody's thinking, why can't we challenge this? Well, it's been done. The Van Ness one is a very unpleasant case I'm going to talk about. That was a deliberate killing and destroying of nests. There's the yacht club, and this is in Quebec, related to a breakwater which caused bank swallows. And bank swallows, by the way, seem to be the latest thing in enforcement. Oops. I seem to have skipped several slides. Oh, okay, I'm missing a slide. Sorry about that. I will go to my notes. There have been some recent cases involving bank swallows. In fact, there have actually been 2 this year in 2016, involving one in a sand pit and the other in a gravel pit, both, I believe, in Ontario, involving significant numbers of bank swallows nests that were impacted. And I said, I'm really sorry, but I seem to have lost my notes and my slides for that one. Here it is. Yeah, 2016, one company was an $8,000 fine for ordering, and in order to develop some bank swallows habitat after destroying the nests of bank swallows in a sand pit. And the other one was a company was fined $15,000 for destroying the nests of bank swallows in a gravel pit. So it's not that there's no enforcement of this. There is enforcement of it. And I want to talk a little bit about that because it goes to due diligence, and we're going to talk about due diligence in just a moment. Enforcement, as Kevin has pointed out, he talked about triage. Enforcement is a matter of, first of all, you have to have law, and you have to have law that's been broken. But so there's the legal question, is there a case here? But beyond that, it's also a matter of policy. Every law enforcement agency in this country makes policy decisions about what they're going to enforce and what they're not. And the simple example of that is when you drive 85 kilometers in an 80-kilometer zone and the cop watch you go by. That's a policy decision. You've broken the law, but they've made a policy decision. They're going after the guy who's doing 120 because he's the one who's actually causing a danger. So that's a policy issue. Enforcement organizations in Canada also have internal policies, written policies on what they're going to enforce, when, and under what circumstances, and how they're going to enforce. So they have a matrix. Like, for example, you can actually get these if you do FOIs, but they have matrices in which they will look at what's the infraction, what they do wrong, what's their history, how serious was it, and what have they done to fix it. So they'll be looking at essentially some of the due diligence things that we talk about in making a decision. Do we issue a warning letter? Do we issue a ticket if they have the ability to do that? Do we go with an administrative penalty, which are new things on the enforcement matrix? Or do we go to a full prosecution? And those are decisions that are made at that triage level. They're made, first of all, they're often made through recommendations and discussions between the enforcement officers and the Department of Justice or the Ministry of Justice at the provincial level. So there's all kinds of decision making that goes into that as to whether or not they're actually going to enforce. So when you've had a problem and the investigators have come out, and then what comes out of it is a warning letter, that's because they've made a decision based on a number of factors. And it might be that you've had a perfectly clean record and they've seen evidence of diligence and they don't see a lot of value in spending the time and effort and money, which everyone's going to spend, to go to an enforcement procedure. So they'll issue a warning letter. Now if you do it again, then that's going to up the ante. I don't have much time left. I want to move on to due diligence, and just to talk a little bit about the concept of due diligence. Sorry. Okay, that's just, okay. So the concept of due diligence comes from a 1980s case from the Supreme Court of Canada of Mr. Justice Dixon. It is, actually it's 1978, I'm sorry, late 70s. Personally, I think one of the most important cases in Canada, in Canadian history. I think the most important case in Canadian history in terms of protection of the environment. And the reason for that is because what the court said was, okay, we have two choices right now. We either have what we call mens rea, which is like a crime, the things that you have to prove, and you can't, and it's really high level on the government to prove it. Or the other end, all the government has to prove is that you did it and you're guilty. There's no defense. So there were two. What the court did is carved out of the middle of that a concept that even if you did the deed, that if you can demonstrate that you exercised reasonable due diligence to avoid it, that you can be acquitted. And what that did, post that, because that case then went on to another case called Bata, which involved the Bata Shoe Company, which was actually charges against directors and officers. What that case did is actually up the ante in terms of companies and individuals, but companies, and understanding that if they exercise diligence to avoid these things, that they can actually protect themselves legally. And that made it was a sea change in the way companies were exercising their diligence in environmental protection. This is the rules that the court set out. So what the court said was, defendants must establish that they exercised all reasonable care by establishing a proper system to prevent the commission of the offense and by taking reasonable steps to ensure its effective operation. Reasonable care does not require all steps, but only those steps that I can't read my slides, that could reasonably be expected in circumstances. And the standard of due diligence is variable and is directly related to things like the gravity of the potential harm. So the higher the potential harm, so you're dealing with a super toxic chemical, the court will hold you to an extremely high standard. So it depends entirely on what, there's a variety of things that go into how high the standard is. The sophistication level of the company that's doing the work, or the individual. There's a bunch of things that go into it. And the courts have there have literally been thousands of cases that have looked at this since then. And they have come up with a number of different criteria for what you look at in terms of due diligence. Here's where the rub is with migratory birds. The first paragraph. Defendants must establish that they exercise all reasonable care by establishing a proper system to prevent the commission. Not to mitigate, to prevent. So if you came to me and asked for my legal advice and said, I'm doing these best management practices, I think it's going to mitigate, I think I'm going to reduce the amount of bird kill or bird nest problems by 80%, there might still be a small number. Will that meet the standard of due diligence? The answer will be no. Because the standard of due diligence as a defense, to get you out of charges completely, is you have to exercise diligence to prevent it. And that's really hard to do with migratory birds' nests. Really hard to do. So then we get back to, I've actually had people say, so what's the point? Well, the point is, of course, is that hopefully your efforts to mitigate will prevent. That's the first thing. And the second thing is your efforts to mitigate will be a consideration in terms of if you do have a major issue or you have a problem or you have an investigation, that will go into the question of what they're going to do about it, because that is important too. So it is important. And it's not, I don't want you to take this as advice to say, well, don't bother doing anything. You absolutely must. But the point being is that unfortunately, unlike other areas in environmental law where you can actually do things that will prevent you from doing it, the only thing to prevent is probably don't do it. The little green sheet that the biologist has been asked a question on what to do. I had to look at that. I won't be here tomorrow afternoon, so I won't hear what all the answers were. But my answer is, don't do it. I mean, you want the legal answer? Don't do it. So that's it. Oh, question.